You're charged with two cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine.
Welcome back to the courtroom where chaos, consequences, and life-changing decisions collide in real time. Today's docket is absolutely packed. We got multiple DWI offenders pushing their luck, a terroristic threat involving family members, theft cases with shocking confessions, and bond violations that could send people straight to jail. The judge is not holding back, and some of these defendants are about to learn the hard way that probation isn't a game. Stick around because this gets intense. Let's dive in.
I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine.
How did that turn?
First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to
How
you.
did that turn?
Let's do probable cause and then we'll,
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here? After you broke my window of the vehicle of my vehicle." Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
and what about the terroristic?
So the terroristic threat, Your Honor, and this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number, threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check here.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm hurting about that person.
I don't want you to have contact with this person. Do you understand? You understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail.
Yes.
Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's two sides to the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about do I have to come to court so I get in contact with him because we have a child.
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in this case and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box while I find you a lawyer. Don't leave until you sign our bond conditions.
Okay.
Right out the gate, we got multiple charges stacking up fast. Notice how the judge starts with the basics. Criminal mischief and interference with an emergency call. before escalating into more serious offense, terroristic threat. Anytime a judge lists charges in layers like this, it's usually a sign the situation has been building over multiple incidents. And here's the kicker. She was already out on bond when she allegedly made the threat. That's a huge red flag for any judge. Now she's facing strict no-contact orders, and the judge is making it crystal clear. Violate these conditions, and you're looking at $5,000 to $10,000 bonds with no one to post them. That means jail until trial. Viewers, what do you think causes cases to snowball like this? Bad luck or bad decisions? Drop your thoughts in the comments.
Mr. O'Neill.
Morning.
Sir, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. All right.
Good morning, Judge. Just 1 second. Pulling up right now.
Okay.
So,
I thought I was supposed to have an attorney here today.
Did you hire one?
No, the judge that I talked to said that I could have.
That was for purpose of magistration, but it doesn't carry with you until the end. You don't have a lawyer at this time.
all right, Judge. On April 12th, 2025, officers responded to a family disturbance call in Harris County, Texas. The officer ID'd the complaining witness by their Texas ID card. The complaining witness stated that the defendant threatened to shoot her. The complaining witness ID'd the defendant by his Texas driver's license. The complaining witness stated that she is the defendant's daughter and they all live together in their grandfather's residence. The complaining witness stated that the defendant threw her clothes outside. The complaining witness stated she asked the defendant to go get them. The complaining witness stated that the defendant stated, "I have something else for you," and then took his hand and pointed it at the complaining witness, stating, "I'm going to shoot you." Complaining witness stated that they were in fear due to multiple guns being in the house and the defendant having a violent history. The complaining witness stated she observed the defendant holding a black long gun. The officer detained the defendant. The defendant refused to ID himself, repeatedly stating, "What is going on?" The Miranda rights were read. The defendant denied all allegations and stated his daughter, the complaining witness, was lying. Defendant advised that he hadn't seen the complaining witness all day long because she was at the hospital visiting her mother. The officer inquired about this, and the complaining witness stated that she did not go to the hospital. It was only her grandfather who went. The complaining witness stated that she was home and the defendant did see her and threaten her.
All right, Mr. O'Neill, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. These are your bond conditions. If you violate these conditions, I will revoke your bond, put you in jail.
Absolutely.
Do you understand?
I don't have.
Just don't say anything at this point. Just don't have any weapons. Don't have contact with this person. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they will potentially file additional charges against you. Do you understand?
Yes.
Okay.
What about the house? That's where all my stuff is at.
What I'm going to do is I'll appoint you a lawyer today. You can talk to the lawyer about what's going on, but I'm going to do everything in my power to protect everybody in this at all costs. You understand? Okay. So look,
She can go wherever she wants. But I'm just asking.
let's do this. Let me appoint you a lawyer. You can talk to the lawyer and we can go from there. Now is not the appropriate time to go through this.
I've been staying at a shelter.
Okay, hold on.
And
I already have an application. So Vic, do you mind appointing him? I already have an application on file. For now, what I'm gonna have you do is I'm gonna have you sign a reset with Victoria while you take a seat in the juror box while I find you a lawyer. We'll have you talk to this person and we'll go from there.
did the reset happen in a few days?
We usually do like a month.
Months?
I'm gonna have you talk to a lawyer today.
This is where things get intense. A terroristic threat charge isn't about terrorism in a traditional sense. It's legally about placing someone in fear of serious bodily harm or death. And because the complainant is a defendant's own daughter, and they live together in the same house, this becomes an extremely volatile situation. The emotional stakes are clearly rising here, and the judge is about to clamp down hard. Notice the judge immediately orders no contact and no weapons. When a judge emphasizes weapons and contact restrictions like this, it usually signals they see real danger. The defendant is also homeless, staying in a shelter which complicates enforcement. But the judge makes it clear, violate the protective order, and you're facing additional charges on top of what you're already dealing with. Do you think the judge is being appropriately cautious or overly strict? Let us know below.
Good morning, Mr. Schaefer. Sir, you're charged with aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Thank you, Judge. The officer made contact with the loss prevention officer of O'Reilly's Auto Parts, who stated that he received an anonymous online tip about a possible theft regarding one of the employees from the 3498 FM 528 location. That's an address. The tip stated that the defendant had made 2 fraudulent returns and kept the money from them. The first return was back on August 2nd, 2024 for $316.50 for three brake rotors. The complaining witness was able to contact the customer and they advised they did not return the rotors. The other return was on January 16th, 2025 for $179. The complaining witness contacted that customer and they also advised that they did not return the product. The total of the 2 returns was $495.50. The defendant admitted to the theft in a written statement. Complaining witness provided the 2 fraudulent receipts and listed on each was Schaefer's unique counter number.
Okay. Mr. Schaefer, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with this O'Reilly. There's not a specific complaining witness, right? So I'll just go into O'Reilly's. Do you understand?
Yes, sir.
Okay, if I find that you do, if I find that you pick up a new case, it's not going to go well. Do you understand?
Sure.
Do you have the ability to hire a lawyer?
Sure, I do that.
Okay, we can have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. I'll have you go to Victoria, sign a reset. We'll have you take a seat. We're losing spots.
I only got one more minute and I'm supposed to.
Okay, well, there's one.
Bond conditions you got to sign.
Okay, so we'll do all that. We'll have you take a seat there and then let me start. Okay, please.
I'll just call up the next one that could be ready. Fine. Theo, come on up.
Sir, you're charged with evading arrest or detention and theft. On the evading arrest, you're facing up to a year in jail and or a $4,000 fine. On the theft, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, officers were dispatched to a theft in progress call in Harris County, Texas. Officers were given a description of the defendant by an Academy employee. The officers observed the defendant walk out of the store passing all points of sale. The officer attempted to detain the defendant for investigation for the alleged theft. The defendant initially complied with the officer directives. As officer grabbed the defendant's wrists, the defendant began to pull away and evaded through the parking lot. The defendant eventually tired out and officer detained him without incident. The defendant evaded approximately 1,271 feet. The officer confirmed with the reportee that the defendant detained was the one who stole a paintball gun, and officer located the merchandise in the bushes at the Olive Garden where the defendant stated he dumped it. Initially, the defendant denied taking anything from the Academy, but when confronted with being told store cameras caught him in the act, he admitted it and led the officer to where he dumped the paintball gun. The paintball gun was retail priced at the store for $140.
Mr. Steele, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any academy. Do you understand? How old are you, sir?
17, sir.
Are you here with anyone today?
Yes, sir. I'm with my sister.
Okay. I'll appoint you a lawyer today. All
Yes,
right.
sir.
Don't get in any more trouble. I don't want to have to put you in jail. You know, if I put your bond at $5,000 to $10,000 and you don't have anyone to put that kind of money up, you'll be stuck like Chuck, man. This is not a good way. All right.
Yes, sir.
So what I'm going to do is I'm going to have bond conditions created for you. Don't get in any more trouble. Don't go to O'Reilly's. What are you doing with yourself? Are you in school? Are you in high school?
Yes, sir. High school. I'm in 10th grade and I'm trying to Find a job right now.
School. That should be your one and only gig, you know? That should be your full-time job because the most, you want a paintball gun? Money. You get money with knowledge. You get that with school. That's your full-time job. Do you understand?
Sir.
All right. I'm gonna have you sign a receipt, Victoria. We'll have you just take a seat in the juror box while I find your lawyer, okay?
Yeah.
Please.
Now we're seeing a 17-year-old in court for evading arrest and theft. This kid tried to steal a paintball gun worth $140 from Academy Sports, and when officers tried to detain him, he ran over 1,200 feet before getting caught. What's interesting here is the judge's tone. He's firm, but he's also trying to mentor this young man. Notice how he asks about school and tells him education should be his full-time job, not chasing material things like paintball guns. The judge is planting a seed here, trying to steer this teenager away from a path that could ruin his future. But here's the reality. If this kid violates his bond conditions, the judge won't hesitate to set a $5,000 to $10,000 bond. And at 17, that means sitting in jail until trial. This is a crossroads moment. Will he take the advice, or will he end up back in court? What do you think?
Good morning, Mr. Garcia. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On June 7th, 2024, officers were dispatched to the complaining witness's residence and met with JV, a minor. The defendant is her older brother. They were having an argument because someone went through his items in his room. The defendant kicked her in her midsection area, causing her to fall on the floor, and struck her with a fist several times. Her younger brother also witnessed this. She felt pain. Defendant left the location before the officers arrived. That concludes.
This is old, huh?
Yes, Judge.
This is from 2024. We're just now getting it? Is it a 2B?
Yes, Judge, it must have been a 2B. We do have another offense from a 2024 date as well, so I'm not sure what brought them in this day.
Mr. Garcia, I'm sending you for a drug and alcohol test. I want to know what, if anything, is in your system now and you're to come back. If you ever take off again, I'm going to make your bond extremely high. No more PR bonds. Do you understand me?
Yes, sir.
You are on bond for a felony as well. Will keep my county safe at all costs. You understand?
Yes, sir.
I'm going to appoint your lawyer today, but I'm sending you for a drug test. You must take the test and come back. You understand?
Yes, sir.
All right. I want to send him for a test.
Can you send these charges?
Judge, we do have a few more agreements, however, the attorney does not.
Oh. Okay, we'll wait. Then let, Mr. Lopez, you were charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, in Harris County, Texas, officer was working patrol when he observed a motor vehicle that matched the description of a vehicle that was recently stolen by 3 armed Hispanic males. The officers conducted a traffic stop. The defendants disregarded officers' verbal commands by staying in the vehicle. The driver continued to disregard commands by putting the motor vehicle in drive and operating the motor vehicle through the parking lot. More specifically, the driver drove approximately 20 miles per hour toward Officer Martin and his motor vehicle. The driver continued to evade for approximately 2 miles until the vehicle was damaged such that it could no longer operate. Defendants were detained and a stolen handgun was located under the driver's seat. The complaining witness mentioned that he was robbed at gunpoint by 3 Hispanic males who took his motor vehicle without his consent.
Charge anyone with the aggravated robbery?
We do not. I do not see that here. I'm not sure.
Mr. Lopez, I'm going to find that there's sufficient probable cause to go forward with your case. Was this in the middle of the night? Was this in the middle of the night? I don't know
Yo
what
no
your
sé
immigration
cuál es su
status is,
estado
Mr.
migratorio, señor López, pero si no está en este país con
End up going to
permiso
jail.
y termina yendo a
Immigration
la cárcel,
finds
la
you.
inmigración lo encuentra,
You know,
solo
on you,
uno
and you will be stuck like
se
Chuck in there.
ahí como yo hasta que este caso se
I
termine.
want you to
Yo quiero
understand
que
that
usted
I'm
entienda
everything in my power to
todo
protect my
para
city.
para proteger a los ciudadanos
And that you become a
que se
danger.
encuentran que usted es
It's
peligro.
really not going to go well.
Eso no le va a ir bien, usted lo entiende.
Yes, sir.
I'm sending you now for a drug and alcohol test, and then you're to come right back. If you fail the test, if you fail to come back, I will issue a warrant for your arrest. Do you understand?
Entiende.
You're ordered not to use alcohol, illegal drugs, and I'm putting a monitor on you so I know where you are at all times, and I'm giving you a curfew because I don't want you out in the middle of the night.
Quiero que usted esté por allá afuera.
Tell me you have the co-defendants, please, so we know who they
Que tienen
are.
las buenas de
Cole, the co-defendants, so I know who to tell them not to hang out with.
para que usted podemos decir con quién no debe estar.
We have a couple of names
Un
here
par
in
de
the,
nombres
Can you just
aquí.
give me like a cause number? That'd be great.
all right. The cause number is going to be 255
Okay?
9562.
That's our cause number.
Oh, the cause number for the co-defendant?
Co-defendant.
I don't see it here in the DIM, so I'm pulling up the offense.
Is Bonilla the only co-defendant?
Bonilla and Hernandez, I believe.
Okay, I don't have Hernandez in this case.
Can you give me one of the cause numbers that you have?
Yes, Judge, I have Bonilla, the cause number is 2559576.
Your Honor, I have Hernandez if you would like that as well.
Tiene la Bonilla y Hernández.
Yes, it is.
What's the other cause number, Paul?
It is 1911823.
So they got Hernandez on the act of assault with the evading.
Yes, Your Honor.
And the evading.
Robo con grabante.
There's a problem with the Retreat case. It looks like they put the defendant as the lawyer also as the, and I don't know if that's so they take care of. But if you want to take a look, they put the defendant as a lawyer. Mr. Luke,
Señor,
it's 255-9576. Mr. Lopez,
señor López.
I don't want you hanging
Yo
around
no
with the other
quiero que
two
usted esté con
co-defendants in
esos
this
dos
case.
acusados en este caso.
Find that you hang out with
Encuentro
them.
que con
Likewise, I will
ellos,
revoke your bond, put you in
igualmente, le
jail.
revoco su fianza y lo pongo en la cárcel.
Don't
No,
danger my city. Do you understand?
ciudad, ¿lo entiende?
Yes, sir.
Okay, I want to sign now. Okay, take a seat for me, sir.
Yeah. Judge, do you want me to appoint or we wait?
Yeah, no, okay. So, no weapons, no contact with the co-defendants.
Okay, this case just escalated fast. We got a defendant charged with criminal trespass, but the probable cause hearing reveals he was in a stolen vehicle connected to an armed robbery. 3 suspects robbed someone at gunpoint, stole their car, and when police tried to pull them over, the driver drove toward an officer at 20 miles per hour before leading them on a 2-mile chase. A stolen handgun was found under the driver's seat. Now, the judge is layering on serious restrictions: GPS monitoring, curfew from 9 p.m. to 6 a.m., no contact with co-defendants, and mandatory drug testing. The judge even mentions immigration consequences, signaling this could have life-altering ramifications beyond jail time. Notice how the judge is trying to track down co-defendants to ensure none of them can associate with each other. That's strategic, keeping dangerous groups apart. Do you think GPS monitoring and curfews are enough, or should the judge have denied bond entirely? Let's hear your take.
No using GPS with a curfew, please. The curfew is 9 p.m. to 6 a.m.
It's being corrected. They have a John Jaworski.
Yeah, that's right. That's the lawyer. Mr. Melendez, I want you to understand something, that you have entered into a plea bargain with the state. I don't have to take this plea bargain, and if I give you anything more than what the plea bargain is, you will be allowed to withdraw your plea, and we can set this case for trial. But did we send him for a test today? Did we send him for a test today?
Drug test?
It was 50 days after when I picked it up.
No, I believe we only did it on day one and you were waiting for him to be clean. But I've already gone through the evidence and got an offer from the state and he decided to accept it. I thought it was 2 months after initial setting and we are now not quite 1 month out. Because I was appointed on 3/28.
Melendez,
18 now.
now within 2 months, have now 2 convictions on your record. If I take this, why would we keep letting you get convictions on your record to hose yourself? You want to take the easy way out in life. That's not a good way to go, because now you are just making it all the more difficult to get jobs. You want to get funding for anything in this life, not with all these convictions you start racking up. Did you start the framing job or no?
Oh, well, he didn't like answer me the next day, but I've been doing school. And I have like every day I do it.
In fairness, I did receive emails showing that he just passed his last course and has now moved on to the next one.
So what course is that?
I went through the mental health. Now I'm in U.S. history.
It's great. You don't want to do a probation to try to keep this off your record?
I don't want to deal with it no more. I've already been coming for like 5, 6 months. I don't want to keep coming and doing it.
When you pick up cases, that's what happens.
I know.
You know, when there are half-ass approach, you get a half-ass result. Now you will end up with a second conviction. You don't want a probation. If you do it, right, depending on how well you do it, I take people off early when they do well. All you have to do is stay drug-free and do probably a class or 2. If you do that, you don't end up with a conviction on you. It's up to you.
It's a strain. It's a strain on my family. It's a strain on me. Like I have to get my mom to come here every time with me. She has work to do. My dad works.
What you would do is you would report by where you live. You don't come to court anymore if you get on probation. Have you talked to him about a deferred?
I just got the offer from the state. I did not discuss a deferred with him. When I talked to him about the ins and outs of things, he told me he preferred the idea of a time served. So that was what I asked the DA for. I did not even ask for a deferred.
You gotta understand that you're only hurting yourself more and more and more. You now, from now on, are looking at a minimum of 90 days in jail, any new cases that you pick up. If you get buyer's remorse within 30 days, we can talk about it. If you have a change of heart where you would want to prefer to do something else, come back and we can talk. But after 30 days, I lose jurisdiction. This ends up as a conviction on your record for the rest of your life. You can never take it off. You understand? You're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you've worked out is 3 days in jail, credit for the 2 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You sure you want to do this? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'll follow you. Good luck to you, Mr. Melendez. Thanks.
Thank you, Judge.
You rolled it. How are you?
Council for Lisa?
You've not been driving?
No, Uber, having rides.
How hard is it to live in this city as big as it is without the ability to drive?
That's something you take for granted.
Sucks, right?
For sure.
That's all I want you to understand is that, it's a privilege. It's not a right. And we take it seriously. And we have so much death on the road. There are certain things in life that are just elementary. You know what I mean? Certain things you're not supposed to do, right? All I want you to do is recognize that and appreciate it. And that's why we do what we do. We put certain conditions on, I'm happy to take them off you now. I just want you to understand that it's not a right. It's just a privilege. You want a right? Go walk. That's the right that you have. Do you understand?
No, for sure.
That's all I want. Okay? All right, man. Good luck.
Thank you very much.
Taking them. Okay.
See you.
Yeah, please. All right. Good luck, Mr. Valencia. All right. Second bond violation. What am I supposed to do?
So his first one was because he picked up a new case. This one, I did speak with him. He is actively in IOP. I did show you those records at the last time that we were here that he got involved in IOP. He is getting drug and alcohol tested at his job too. He is a Marine recruiter. He did pick up some non-alcoholic beer. A lot of them still have alcohol in them. He was trying to still hang out. I get it. He realizes that that's obviously not going to work either at this point, that we're staying away from everything. But he did go get that.
I have to beg you not to violate your conditions of bond. Am I supposed to just be happy and let you go again? You know, either you have a problem or you just don't care about bond conditions.
Yes, Your Honor. I did.
Just, whether you say yes, whether you say no, whether you say Your Honor, I already know, you know, I know my name. I don't. The point is that you just don't get it. And what do I need to do to ensure that you don't get it?
So I have had several conversations with him, Judge. He is taking this seriously.
You had conversation beforehand.
I understand. He is actively involved in his IOP and has been continuously going to that. He is trying to make a change. He thought that he was doing something better for himself at that point. Obviously, that didn't work out. Right after do you remember the date? It was in March, right?
Yes.
Let's see.
I have like 2 weeks left.
So, let's see.
This is a critical moment. We got a defendant who violated bond conditions twice. First, he picked up a new case. Now he's been caught with non-alcoholic beer, which, surprise, surprise, often still contains trace amounts of alcohol. The judge is visibly frustrated because this defendant keeps making poor decisions despite being in an IOP program and working as a Marine recruiter. Here's the legal reality. When you're on bond, the judge can set strict conditions, and violating them, even seemingly minor violations, can land you back in jail with no bond. Now, the defendant is being offered a plea deal, and the judge is trying to get him to accept deferred adjudication or probation to keep a conviction off his record. But the defendant wants time served because he's tired of coming to court. Big mistake. The judge warns him. If you take this conviction, you're looking at a minimum of 90 days in jail for any future offense. Viewers, would you take the easy way out or fight to keep your record clean?
So let's do this.
He had an initial appointment February 12th, but he did go into custody at that point. So then he had to reschedule it. So the beginning of March, he got involved.
Sending him for a drug and alcohol test.
Absolutely.
I'm sending you for a test now and you're to come right back. If you fail the test, you can fail to come back. I will revoke your bond. Do you understand?
Yes, sir.
Okay, take a seat for me.
Okay,
And then
let's judge.
just leave me your cell phone and then I'll get a hold of you.
Okay, do you want it now?
Don't speak it out loud.
Okay.
Yeah. Good morning, sir.
Yes, sir.
Sir, you were charged with 2 cases. You're charged with driving while intoxicated, second offense. You're also charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine on each of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Your Honor. On April 10th, 2025, officers were dispatched to a motor vehicle crash in Harris County, Texas. An officer already on the scene advised the officer responding that the defendant stated that he had a firearm inside of the vehicle that belonged to him. The officer identified the defendant by his Texas driver's license. The officer observed the defendant to have slurred speech and watery, glassy eyes. The officer observed an odor of alcoholic beverage emitting from the defendant's breath. The defendant consented to perform standard field sobriety tests. The HGN was a 4 out of 6. The walk-in turn was a 3 out of 8. The one-leg stand was a 2 out of 4. And the officer located a handgun inside of the defendant's vehicle during an inventory search of the motor vehicle. The defendant refused to provide breath. A blood warrant was obtained and his blood was drawn.
Okay. Can you tell me when was the first DWI? Number 1. How many DWIs? Number 2. Number 3. Does he have a valid license, please?
The date of the first DWI, Your Honor?
Correct.
2023, Montgomery County.
Okay. What was it? Well, obviously, it did some time. Any other DWIs?
No, Your Honor, but if you find it pertinent, a reckless driving from 2019.
Was it pled down?
It's, yeah, convicted on a lesser charge.
So what was the,
The original,
right?
Your Honor, I believe the original charge was a driving while intoxicated.
Your Honor, I'm running his license now. They haven't given out cold access yet. It's eligible, Your Honor. Well,
You know what a third DWI is in Texas? A third DWI is a felony offense of the third degree where you're looking at 2 to 10 in the penitentiary. I don't know what is going on with you, Mr. Carrillo, but if I find that you're consuming at all, I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. On your other ankle, I'm going to put a GPS monitor on you so I know where you are at all times because I don't want you out in the middle of the night. And on your other ankle, you're going to get a SCRAM so I know that you're not consuming. If you have a problem with drugs or alcohol, now is the time for you to take care of it, because if it becomes a problem while you're on bond, I will do it for you and you're not going to like the way that I take care of it. Do you understand?
Yes, sir.
You are not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you use, I will revoke both of your bonds, put you in jail, no more PR bonds. Do you understand?
Yes, sir.
I want you to understand one more thing, that I'm going to do everything in my power to protect my streets at all costs. Watch the news. Every single day, we have a DWI fatality in our town. It's unacceptable. Do
Yes,
you
sir.
understand?
Yes, sir.
I'm not taking away your privilege to drive, but if I find that you're consuming, it's not going to go well for you. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Pham, and he will tell you if and when you have to come back to court. So for the time being, I don't want you out in the middle of the night. We can talk at a later date if things, okay?
Your Honor, would the court consider waiving the fees?
Absolutely.
Thank you.
All right. Good luck to you, sir.
Thank you.
Right this way.
So you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 12, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash and made contact with the defendant, who admitted to drinking 2 to 3 beers. The law enforcement officer observed the defendant stumbling and leaning on his vehicle to keep his balance. The defendant stated he did not remember what color the light was when he rolled into the vehicle in front of him. The defendant refused to perform standard field sobriety tests, but consented to a breath test and blew a .211 and a .204.
Ready to be honest?
No, Your Honor. And not in this county. I'm going to check and make sure.
Mr. Hernandez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
No prior DWIs, Your Honor.
Okay. Does he have a valid license? You mind?
Blaze, can you check the license for me?
yeah, sorry.
That's all right.
Mr. Hernandez, you are not allowed to drive unless you have a valid license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive as well. And that is a condition of your bond. Do you understand? Darla, do you know if he has a license?
I have made ALR request, but I didn't verify yet. No judge.
Sir, I don't have there was no driver's license number in our system.
You know the driver's license number?
Do you have a driver's license?
Yes.
Okay.
I'll let you guys check to see. Darla, I just want to make sure that it's eligible to drive. Otherwise, I'm going to have him sign an affidavit. Not to drive. So if you don't mind,
I did find a driver's license number.
Joseph, I see your motion. Is that all you got?
Yes, sir.
I'm signing it for you.
Thanks, Judge.
Got it.
I can step back, Judge, we can verify that, and if he does need it, I can then.
Yeah, just let me know.
Signed and everything.
Okay.
Okay, thank you, Judge.
Absolutely, for sure. So for now, you will get with pre-chop for your bond conditions. Don't use. You understand? Okay. All right, thanks, Carl.
Sorry, Aaron.
Got it.
Okay.
All right, okay. So we'll have you sign a receipt, you'll get pre-trial, and then you're free.
And there you have it. Another intense day in the courtroom where real lives hang in the balance. We saw everything from terroristic threats and family violence to repeat DWI offenders pushing their luck and juveniles at a crossroads. The judge made it abundantly clear: violate bond conditions and you're going to jail. Period. GPS monitors, SCRAM bracelets, curfews, ignition interlocks. These aren't suggestions. They're lifelines to keep people out of prison and communities safe. The stakes couldn't be higher, especially for repeat offenders facing felony charges that could mean years behind bars. If you found this case breakdown as jaw-dropping as we did, make sure to hit that like button, drop your thoughts in the comments below, and don't forget to subscribe for more real courtroom drama and legal breakdowns. We'll see you in the next one. Stay safe out there,